Hi, this is Rahul Reddy. We are live here from Houston, Texas. Along with me is my business partner, Vi Hong.
Hi, I'm Vi Huang. Nice to meet you.
Today we are here to cover the immigration issues as we usually cover every weekday Tuesday at 5 p.m. Central Time. Now, the things are not as good going in the H-1B. Now, you are the head of the H-1B department. What's going on the change of status applications from STEM OPT to H-1B and especially from CPT to H-1B? Can you describe what's going on that?
Well, we're seeing a lot of denials on the change of status from CPT to H-1B and OPT STEM to H-1B. So when that denial hits, the unlawful presence begins to kick in from August 9th. And so it's very important to remember the February 4th date because that is when the 180 days deadline is.
So August 9th, 180 days is actually hitting on February 4th or February 6th. So in other words, if the change of status has been denied for you, and if you are going to be in this country, if you cross the February 4th, you're accumulating the 180 days of unlawful presence. So if you accumulate 180 days of unlawful presence, you will have a 3-year bar on you. And if you accumulate for 365 days, you will be having a 10-year bar on you. So you have to be careful when you get the change of status denial, you are accumulating the unlawful presence. You need to cover your base, otherwise you will be barred from entering into this country forever. So you better you better consult the immigration lawyer once you get the change of status denied. Any trends in the RFEs right now? What's going on the RFEs in general?
There are a higher increase in RFEs, but there are no straight denials based on no RFEs being issued.
So what about the rumor that things are playing around that the USCIS might deny the H-1Bs without issuing an RFE? Have you seen any of those things?
We haven't seen that, and that's especially because employers have been giving really good documentation, and as long as you provide the necessary documentations, USCIS is not going to outright deny a case without issuing an RFE first.
So what about the notice to appear? Have you seen any of the change of status denial getting the notice to appear as of now?
No, we haven't.
Okay. Well, I want people to be careful for those people who are accumulating the unlawful presence once the change of status has been denied. We may be getting the notice to appear for these people once the February 4th starts, and when that occurs, you might be accumulating a 3-year or 10-year bar, so you might want to be careful on those things. Any questions that are going on? We're going to take live questions on YouTube and also on Facebook, so if anybody has any questions, please post it on the Facebook and also on the YouTube.
Well, Rahul, I do have a question about the H-4 EAD. Have you heard any news on that?
Yeah, H-4 EAD as of now, there are no news going on. There is no proposed regulations on this one. There are a lot of rumors saying that the Congress is now passing a bill prohibiting the president to take any action on the H-4 EAD. In other words, the Parliament does not want the H-4 EAD to go. That's a bill which is proposed. But I will be very surprised if that bill is going to be passed. Even if that bill is going to be passed, I'll be very surprised that the President Trump is going to sign the bill. So I'm not expecting that to go. However, when it comes to the Trump administration on the H-4 EAD, there is a chance that they may restrict the H-4 EAD. However, when the H-4 EAD is going to be restricted, they are going to give time for the people who are already on the H-4 EAD. A lot of people fear that it will be on day one, the H-4 EAD will be cancelled, but when I have seen the undocumented aliens to have been removed the EAD, the Trump administration has given them 3 months time to keep extending the H-4 EAD. I'm sorry, the EADs for the undocumented people. There are about 900,000 people, undocumented people. But when it comes to the H-4 people, I'm expecting that he will show the same courtesy what he has shown to the H-4 EAD people. To the undocumented people. Some questions coming out on the YouTube Live. How long it takes for the EAD approval? Right now, it's taking approximately around 90 days to 100 days for the EAD to be approved.
Okay, I have a question from Facebook Live from Varun. Is the new LCA going to impact the change of client location in the MSA? No, well, it does. It does. The new LCA will require the legal full name of the end client. So it's important that you provide that detail in order to file an LCA. But in regards to the MSA and when there's a change of location, all of that remains the same.
So can you educate more, V, on the new LCA? When did the new LCA system came in? What are the changes that you can describe to the audiences? What are the things people need to be careful about?
Well, the new LCA became effective this past Monday, November 19th. And in that LCA, it requires the full legal name of the end client if the worker is going to be at a third-party location. Along with that, it requires if an H-1B dependent employer is requesting exemption based on a higher master's degree, they will be required to upload the degrees and certification in order to prove that exemption. But other than that, the LCA details are quite frankly the same process.
Have you filed any LCAs after the new regulation?
We have. We're going through the process. It's a bit different in the iSort account, but it is easy to understand as long as you really read through the questions that they're asking.
Now, with regards to the change of status applications, guys, I want you to be very careful one more time. If it's CPT to H-1B change of status has been denied, you are in big trouble. I have to also want you to warn that whenever there is an RFE on the CPT to H-1B issue, it's always the change of status is getting denied. This day one CPTs, we do not, Reddy and Neumann PC does not consider day one CPTs to be as legal because these universities, there are only a handful of universities that are giving the day one CPTs. We're having a lot of problem with these universities because they're not even conducting a classes. I spoke with a lot of people. Some of the people said that their universities only conduct one class in the entire semester. Live classes only one. And there are some universities that are conducting one class a month. And we don't consider that those universities are legitimate universities, and those CPTs we don't consider to be legal. So if anybody wants to, is contemplating in moving into those universities, please do not. And if you're already on CPT with those universities, we recommend that you consult a lawyer because you might be accumulating the unlawful presence from August 9th onwards. Any questions from Facebook?
Vikram asked how long processing time is taking for transfer H-1B. Now we know they are taking a long time because premium processing is not available for those cases. They are said to reinstate premium processing in February, and at that point we can then upgrade the case and hopefully that will be available. But for now it is taking at least 3 to 6 months.
Mr. Salve is asking question, is it recommended to file for H4 EAD through a lawyer or can I file by myself? Well, we always recommend to file through a lawyer, but as such we have not seen any legal arguments necessary for H4 EAD. We have not seen any significant denials of the H4 EAD. So it's up to you if you want to use a lawyer. Definitely if it's any other H1B or PERM or something, I would definitely say go with a lawyer. But H4 EAD, I'm fine if you do either way. There's not much legal things there on the H4 EAD. You must have the I-140 approval, the marriage certificate, pay stubs, your status and the spouse status, and you should be good to go if you file in the proper service center though.
Question from Krishna asked that he received a denial notice for an H-1B quota case and whether he should do day one CPT. And again, the answer is no, do not do day one CPT. That is resulting in these quota cases that have a change of status denial, and then you run into the issue of the unlawful presence and potentially a notice to appear. So avoid that at all costs.
Can we work on a remotely on a H-1B from a different state in USA? And if somebody wants to work remotely on a H-1B, how do you document in the H-1B?
If they want to work remotely, you can still file reflected on the LCA, and it just has to be documented in the petition that you are working remotely. Have the client letter acknowledge that you are working remotely. So providing that clear documentation that you are working remotely, USCIS will likely accept that work location.
Because has this question, how long it's taking for an I-140 I-140 EB1C case to get adjudicated? He has his case pending for 8 months. Yeah, it's taking approximately around 12 months nowadays for the EB1C category I-140 application. Now, unfortunately, in the EB1C category, you do not have a premium processing, so you're forced to wait until it has been adjudicated. Yes, you do. If you get an RFE, it's going to increase the time for the adjudication, but as such, it's taking about 8 to 12 months right now.
Okay. And speaking of I-140, did he ask? He got a substantially comparable role RFE for I-140. Now, what's the basis in that comparison of job duties?
Normally, when an employer is documenting that employer is documenting that the position requires a certain job description, then he needs to document that the employee is qualified for that position before he joined this job. So if he had the experience or not, need to be documented in the RFE response. Is that what it is?
Yeah, I think that's what he's asking. And if it's with the same employer, it has to be 51%.
It's actually 33%. If you're documenting the same, if you're saying that you gain the experience with the same employer, you need to document that you have a 33% job difference from the previous job to your job. Normally, our office requirement is about 51%, but the legal requirement is about 33% job difference between the previous job. The reason why they are saying is that if the company is hiring a foreign worker without that experience for the position before, why can't they hire the US workers? So normally people join at a lower level, they move it to a higher level. When they do that, they need to show the job difference, the job duties difference should be at least 33% different than the previous job, especially if they are gaining the experience with the same employer in the I-140. We are also noticing a lot of problems on the stamping issues at this point of time. Those people who are going for stamping are facing a lot of issues in the Trump administration. We recommend that if you can avoid the stamping, if you are in the country, if you avoid stamping, that would be much better rather than actually going for the stamping issues. If you are going for the stamping issues, we do recommend that you consult with a lawyer to make sure that you are in complete compliance with all the H-1B thing. Normally when people go to the stamping, they don't even read the H-1B application. And some of these people, then when I speak on the consultation, their Facebook says that they're actually working for a different company.
Or their resume will say that.
Yeah, and then their LinkedIn says they're working for a different company.
Yeah.
If your client is Pepsi and your employer is ABC Inc., don't list Pepsi as your employer, because you're deceiving not only, I don't know whom you want to deceive, but you definitely are ending up into trouble. Your employer is not Pepsi. If it's not Pepsi, it's not Pepsi. Just list your end client. They are watching all your social media, so you need to be careful what you're putting on the social media. Now, if you're putting the end client, you need to be very careful on those things.
There's a question from Anam. He's changing from B2 to F1, and he's received an EB3 combo card, and an I-485 is under process. Can he stop attending class?
He got EB1, what?
EB3 card.
EB3 EAD card. Yeah, if you got an EB3 adjustment of status filed and you got the EAD card under the adjustment of status, yes, you can stop going to school, you can continue working. Absolutely no need to continue going to school. If you have an EAD approval through the adjustment of status, you don't need to worry about it. With regards to the quota in April of 2019, what are you expecting? First thing is that how many applications you are expecting. The second thing is that what are the expected changes for the April 2019. I know this is the financial year for the 2020, which we filed the application in March. what are the expected thing? I know there's a lot of rumor going on that USCIS want to change the whole system on it.
Right. So we're expecting them to change the way the lottery will occur. So what's potentially going to happen is that these employers have to register their name and the employee name, and based on that registration, the lottery will then be happening, and based whoever is selected, then the documentation will be provided at the later end of that. Now, that was kind of mirrored from the 2011 process, right?
Yes.
So they may be a cut down on the filing or an increase. I really don't know. What do you think?
I think so. With the kind of impressions that is going on, especially the denials from the CPT to the H1B, and some of the denials that we are noticing, there might be a decrease in the amount of the H1Bs getting filed. That's my guess. I can be wrong, I can be right, it could always be different. As what V was pointing out was that these suggestions on the lottery system to be conducted online, in 2011 they did propose all these things, they never went through those things, but now they want to go through right now because they expect that that the whole process of the lottery system is flawed because the amount of cases that are getting filed, mailed, I mean, it's humongous process. And then for what? Every 3 cases that we file, I mean, 2 cases get back almost. I mean, come on, it's a ridiculous thing. Hopefully with all the development what the USCIS is doing, if this one, the lottery system, they're going to do it online, that will be the best thing that they can do for themselves to reduce all the expenditure for ourselves and for all our clients. Because in that way, we don't end up filing all the applications, we only end up filing the applications that were been selected in the lottery online. Hopefully they will come up and do that thing.
Yeah, and we won't really know much more information until next
year.
year.
Well, we will come, until about January or so, we might be able to know clearly. Since they already proposed those things, they might publish the final things, what they want to do, hopefully so by January, so we'll be prepared in April, hopefully so. If not, then it has to be the next year. Hope they're going to do it earlier.
Right.
Lots of questions coming on and these things. The question that came is that from YouTube is, in February 2018 we're going to have the premium processing to be introduced back again. Now, can you explain to the people what are the things that you can file in premium processing, what are the things you cannot file right now, and most probably will be eligible in February to file a premium processing?
Right, so right now what can be filed in premium processing is an extension without change. Now that means that the project and the terms and conditions of the existing employment with your current employer is exactly the same, and therefore you're filing an extension without any change, and therefore a premium can be used. But for now, that's the only thing that premium can be filed for. Once February comes around in 2019, then any cases that's an extension with change or transfer or an amendment, then those can potentially be filed with premium processing.
Are you sure that February 2019 this administration is going to allow the premium processing?
I'm not sure, I'm just hopeful. But the way things are happening, it may be delayed. But
Jay is asking this question. It's a very tough question. I did answer the question, but I want you to answer the question, because you are the head of the H1B department in our office. Can I join the end client with the receipt notice without the approval?
I would not do that. Now, at today's day and age with the Trump administration, we know that there's a very high risk of you joining with the end client with a receipt.
I may disagree with V on this. If I were, because these end client jobs don't come out whenever I wanted them to come, so I may be losing the opportunity. The chances of approval with the end client is higher, so I may join on the receipt notice with the end client. That's my opinion, and that's V's opinion. Then you can, based on this, you can judge which ones you want to follow. It's definitely risky if the denial comes in with it, but then you're also losing an opportunity that you may never get it again if you don't join the end client. If you don't join the end client, you may lose a job opportunity. Obviously, both of our answers will be the same. If you're moving from one consulting company to another consulting company, both will say no. But if it's an end client joining, we is saying she's not going to join if she were there. I'm saying I would join because I may never get the opportunity. And I do got 2 questions on YouTube on that. How long it's taking for the I-140 for a EB2 to be adjudicated? Right now, it's taking anywhere between 6 months to 8 months for the EB2 to be adjudicated under the I-140 to be adjudicated. Now that's for EB2. Now EB1C is different, but EB2. Now if you're an EB2 though, I would recommend that you file a premium processing because you have the availability of premium processing. You have a lot of advantages to get the I-140 in premium processing. Number one, you get an I-140 result soon because once the 180 days has been passed after your I-140 is approved, you can take that I-140 to move to a different company. You can do, your H4 EAD can be filed. A lot of different options will open up if the I-140 has been approved earlier. So I would recommend in your case that you should get the premium processing done on the AB2.
Himana asked on Facebook, while his H-1B is pending, can his spouse travel to India with his original approval notice until 2020? And the answer is yes. So as long as your spouse comes in on H-4 with a valid approval notice, that should be fine. So she should be able to come in with an H-4 stamping until 2020.
Can you emphasize on the latest bill introduced in House against EAD removal? Well, actually, Sidhu from YouTube, the introduction is more about saving the H4 EAD, not actually removing the H4 EAD. But the chances of this saving the H4 EAD going through the Parliament, through the lower house and the Congress and the Senate, and then President Trump signing is very rare. We do not expect this legislation to move any further, because to remove the H4 EAD, they don't have to go to the Parliament, I mean to the Congress. They can do, the Trump administration is already poised to take the H4 EAD off. The matter is when he is going to take off. So the introduction in the Congress is more to save the H4 EAD, but I don't think so they would be able to save unless the Trump administration changes the mind, or maybe this keeps passing on to the next administration. Hopefully so, then the next administration might take a decision. How difficult is it to transfer from H4 to H1B?
As long as there is a valid job offer for an H1B, the risk of filing any H1B is just the same. So it's just up to what kind of documentation can you provide, whether you were maintaining your H4 status at that time, and just the legitimate job offer and the terms and conditions of the H1B.
Yeah, but you don't see any risk just because the person is an H4 to H1B as compared to the F1 to H1.
Right, yeah, I don't see any risk.
In fact, I believe that, other than the lottery chances for the master's degree, H4 to H1 has a better chances of approval because status issues are not of a big matter. Whether you're working in the proper position or not, H4 people, if they're working on EAD, it doesn't matter whether you're working in this position or that position, because H4 EAD, there's no requirement that you have to work or not work. So the chances will be much brighter to move from H4 to H1B. Now, of course, you have to wait for the quota to come in. However, if you have maintained in H1B before, and now you are on H4, you want to convert into H1B, you right now, since there is no premium processing, you have to wait for the H1B to be approved to work unless you have a H4 EAD. Any questions from there? Jay Kishan has this question. I got an initial RFE on the H1B for specialty occupation, employer-employee relationship. He got a H1B RFE and employer-employee and specialty occupation. Well, welcome to the gang. I mean, that's everyday story right now.
Yeah.
It's nothing different. We are noticing a lot of it, but I would recommend that you hire a proper law firm to respond to the RFE. Don't take it easy. The denial ratings at this point of time is between 25% to about 41%. So you might want to be very careful on responding to the RFE. You need to get the proper end client letter. You need to make sure that your vendor letter is there. You need to have the statement of work. You need to have the proper documentation. The most denials that recently that I noticed was that either the end client letter or the vendor letter indicates that the position requires computer science, engineering or related degree. And that's been number one reason for denial in the preceding 4 months. If the position, what the USCIS is telling, when the employer is asserting that the position requires engineering or related, they're saying that it's not a specialty occupation. For the H1B to get the approval, it has to be a specific degree. And the USCIS is telling there are about 34 or 35 different engineering categories. If the position requires any engineering degree, then it does not qualify for the specialty occupation. I would say that this particular wording, which a lot of companies and a lot of lawyers were used to in the end client letter and the employer letter, is causing the biggest denial reasons recently. Again, if the end client letter or the vendor letter or the employer indicates computer science, engineering or related, then there is a good chance for denial. I would recommend that when you're filing, I mean, it's not that certain things cannot be cured at the RFE level. If the employer has stated that the position requires a computer science, engineering are related, I mean, we cannot, it's going to be hard to counter that one. So it's better that when you file the H1B application, you need to have those things. And sometimes when you're in an extension process, when you're in a change of employer process, when I see those things, I know that I'm going to get a denial. Sometimes I just file one more application as a safety method so that you can get, if that gets denied, you may want to rely on the second application. Now that may not be possible for the cap cases, but the non-cap subject cases, you can do that.
Yeah, so I mean, to build off on that, so what kind of language would you want the client letter to have in that?
I would like to have the client letter to, I mean, ideally, if that's what true it is, that the ideal language would be that the position requires computer science or closely related degree, period.
Yes.
Nothing else. Computer science or closely related. Computer science, engineering, you are gone. I mean, that's been the number one reason for the denials in the past 3 to 4 months. Dan is asking, V or V? What's your name?
It's V.
It's VY. It's not VVV. It's not VI. It's VY.
It's VY.
Let's go to some more questions.
There's not that many questions. Well, let's look.
Can an approved H1B transfer to a new employer with a... good question. This person got H1B approval without the I-94. Can it be transferred to the company B without getting the stamping? The answer is no. Here is the reason. If the H1B approval comes without the I-94, technically you are not counted towards the H1B number. You will be considered to have been counted toward the H1B number under two circumstances. When you get the H1B approval with the I-94, or when you get the H1B approval, when you get the H1B approval, when you go to the H1B approval, get the stamping. So once you get the H1B approval with the stamping, then you are counted towards H1B number. In your case, you got the H1B approval without the I-94, so you're not technically counted towards H-1B number. You cannot transfer from company A to company B.
Anam from Facebook is asking, how long do you need to wait for an employment-based green card interview after submitting the 485?
Right now, it's taking approximately, all over USA it's different. Right now, because March of 2017, they changed the rules for the adjustment of status if you file an application. I would say somewhere between 12 months to about 18 months it will take, depending on which district you are in. Right now, if an adjustment of status application has been filed after March of 2018, it's guaranteed they will not give you the green card unless they interview you. Only after they interview you, they will give the green card. And I would recommend for the interview to take a lawyer with you, because recently when I have gone to the interview, they went through every piece of bit. And my client had a chemical engineering. How come you have a chemical engineering degree and now you apply for the computer position? They even asked the client, hey, can you give a code for the SQL? Because it's there in the job description. I was like, what is this guy going to answer? I don't know, man. I don't know. I never know what the SQL code. But obviously my client was very good in the particular language. Of course, if it's not there, he wouldn't be there. So he answered very good. We got the green card. But they are going through each and everything. And I asked the officer after the interview is over, are you a software professional? He said, yes, I'm a software professional. He's been recently hired in the district office just to interview the employment-based green cards. So I wondered, so I want people to be very careful on those things when they do it.
And Alon from Facebook asks, so with a transfer pending petition, you can work beyond the I-94 expiration date, and the 240-day rule does not apply.
So when does the 240-day rule apply?
That applies when there is an extension pending. So assuming there's an extension pending for your case and then your I-94 expires, you can only work based on that pending extension 240 days after your I-94 expires. What happens after it expires, we tend to recommend filing in another extension to tack on after that 240 days so that you can continue working. But can his wife continue working after her H-4 EAD expires?
No. Once the H-4 EAD expires, you have to cease working immediately.
Yeah.
That rule, what we said, is applicable only for the extensions, and which he said that there's a 240-day rule limitation, and the transfers, which there is no 240-day rule, they can continue working until the decision has been made. But H-4 EADs, once the EAD expires, you have to stop working immediately.
So Shriti is asking, if her H-1B in Quota case is denied, what are her remedies? Can she join another degree to stay in status?
Yes, you can join another college immediately to maintain the status. That is available. However, we strongly recommend that you do not apply for day one CPTs. You do not join any university that is giving day one CPTs, because we don't consider them to be proper universities. One question that came up from Rahul Reddy is that, what are the consequences of downgrading from EB2 to EB3? There are a couple of things that I want to explain in EB2 to EB3. Normally, 99% of the time, you can downgrade from EB2 to EB3 without changing the labor certification. You can file one more I-140 using the same labor certification. I know the rules of the labor certification that it's only valid for 180 days, but if you have filed an I-140 before, that rule is not there. You can use the same one. And when you downgrade it, you still have the EB2 approval, so you will have multiple applications going at the same time. Do I downgrade it right now, or do I wait for my date to be current? What I normally recommend is that if your priority date is not current on EB3, I would not downgrade it right now. I would wait for the priority date to be current, and then if it becomes current for EB3, EB3. I will downgrade your application to EB3. Simultaneously, I will file the adjustment of status along with the EB3 application. In that way, you are safe because you don't want to do that extra expenditure because these EB2 and EB3s, they keep moving front and back and you never know which one is going to go which way.
So Srinivasa asks, how long are PWD process taking in EB2 category?
Well, EB2, EB3, they're all prevailing wage documentation for the green card application are the same, and what he's speaking about is a perm application. It's taking approximately around 4 to 5 months, in some cases 6 months, for the prevailing wage determination. Now, there are different ways, strategies that you can discuss with your lawyer before the prevailing wage determination is already issued. You can do the advertisement, so you can save some time. You're taking a risk by any chance if the prevailing wage determination comes higher. You may want, the company might waste some money for advertisement. But if somebody is coming very close to the 5th year and they might run out of the 6th year, I may consider doing the advertisement and recruitment process before the prevailing wage determination has been done. So you may want to check if you want to expedite. But yeah, it's about 4 to 6 months is the prevailing wage determination time right now.
Okay. Prashant asked that there's someone that has a completed 6-year in H-1B and has an I-140 from a previous employer. He came back in on H-4 and is wondering if he can file for H-1B again.
Why not? If you have an I-140 approval, but the only caveat is that that I-140 must not have been withdrawn before January 17th of 2017. That's the number one condition. The number two condition is that it must not have been withdrawn within 180 days after it's been approved. Now, whether that I-140 belongs to company A, company Z, Y, A to Z, it doesn't matter. It doesn't matter. You can come here on H4, you can apply for an H1B, even if you have completed the 6 years of timing, you are good. Absolutely no problem with it. But two conditions. I-140 must not have been withdrawn before January 17th of 2017, and it must not have been withdrawn before 180 days after it's been approved.
Yeah. And Praveen asks, how many months is it advised to apply for an H-1B extension? Well, you can apply for an extension as early as 6 months.
That's right.
So the sooner the better, especially now without premium processing. It's better to start early.
Well, you still have the premium processing, so it still is advisable to do 6 months. But what about the cases where the statement of work says that the position is only available in March, and he has 6 months? What do you do at that time, Avi?
Well, hopefully, maybe it'll get an RFE, and then at that point you can supplement that with another work order that shows there's another 6 months.
Would you wait until March if my H-1B is expiring in May to apply for the extension, or would you file it right now?
I would wait. Just that you can get a longer work order, and then you can actually show USCIS that there is work beyond your expiration date.
Yeah, sometimes these are very tricky questions based on the state. These are very sensitive issues. Normally by default we'll say apply as early as possible, but then there are exceptions that are there. So you may want to consult V, and she's very good in H-1Bs at any point of time. We're trying to get as many questions as possible, but if we cannot get to your questions, you can always make an appointment with V or me at rnlawgroup.com. Yeah. A lot of questions, but a lot of questions are repeated.
Still repeated, yeah.
How long can the employer hold a H-1B without withdrawal? Jay, normally it's not recommended for the employer to hold the H-1B when the person leaves the company, but it's up to the company if they want to. It's their risk, it's not the employee's risk that they are not withdrawing it. But they can hold it. And this happens especially when the person moves from company A to company B and the transfer gets denied. They can always go back to company A if they have not withdrawn the company A's H-1B approval. There are some nice companies that would do it for you when you are moving to end client. Your consulting company does not withdraw the H-1B. If by any chance the end client H-1B gets denied, you can come back to the consulting company and you can work if the H-1B validity is there and if they have not withdrawn the H-1B.
Ravi asked if his wife, who has a H-1B, has not traveled, but she wants to travel with an H-4. Can she do so?
She has the H-4 approval stamping in the passport. She has the H-1B approval. Yes, this answer was recently clarified. She can go and come back on H-4 stamping because her marriage is still valid and you still are maintaining the H-1B. Hopefully so she can come back. But once she comes back, she cannot work on the H-1B. She is subject to the H-4 only because she got the I-94 for H-1B.
Rahul, are there any concerns or negative regarding filing under an EB1 category for a green card?
EB1C,
EB1.
EB1. Well, there is not much concerns to file. I mean, you can always file. But there are three categories for EB1. EB1A, EB1B, EB1C. EB1A is for extraordinary ability. Normally, if you get a Nobel Prize or Oscar award, yeah, you're automatically in. Even if you get a nomination for Oscar or Nobel, I can say you can get into EB1A category if you're the main nomination, not some side nomination guy. But if not, there are 10 requirements. You have to meet 3 requirements. Those are very tough requirements. We have seen a lot of denials in the EB1A category. A lot of people ask, I'm a manager, I'm an upper level manager, can I file? No, it has to be extraordinary person, not just a simple manager. So if you are, probably one of the founder of the WhatsApp application, yeah, definitely. You are the architect for the Facebook, yeah, definitely. So if you are something that are unique, or the self-driving cars, you are one of the architect of that, you may fit into the extraordinary category. When I say architect, I mean say software architect. So if you are any of those categories, you might want to evaluate that into EB1AC with your lawyer. Typically, I don't entertain people unless they have about 3 or 4 patents on their name. The patent doesn't have to be on your name, even if it's on your company name, and you as a worker listed there, I might consider. It's very hard, but if you can always inquire into it. If you are one of those things that I said or come very close to those particular criteria. The second criteria is EB1B category. That's outstanding researcher category. That's normally is applicable for doctorate people who are in the research and they are doing in the research field. This is a little bit lesser, easier criteria to file, but the organization must be involved in the research. Typically, software companies most of the software companies, 99% of them, might not qualify. Universities or research institutes do qualify for those things. But a lot of universities will be very hesitant to file these EB1B categories because they need to be in a tenured position to file the EB1B category. Now coming to the EB1C category, these are the multinational executive managers. But this question also comes very often to me. I'm a multinational executive manager. It's not just you. Year out of 3 years, otherwise you are not eligible for EB1C category. But it's good, and EB1C is also backlogged right now. You may, if you qualify for EB1A, you may want to check with your lawyer to see if everything is going okay. Yes.
Srinivas asked that his wife H-1B got picked up in the lottery, but they still haven't heard anything yet. Can they still keep out hope?
Yes,
So,
we have about 10% of the cases that are still picked up in the lottery, but they have not been adjudicated. They have not been issued an RFE, and we cannot do the premium processing for them. And then there are some of the people who are on STEM, their things are going out of status, and if they're on the cap, they cannot continue working after the September 30th. So these are all the sad situations that the administration has put in.
Yeah.
We're getting a lot of questions, but I guess we have to leave. Any other things that you want to add up to before we conclude the
No, I-
meeting? Thank you again, guys, for coming in. Thank you, V.
Thank you.
And if you guys can always make an appointment at rnlawgroup.com. Please don't forget that we have a daily conference call that you can attend. You go to rnlawgroup.com, our conference call details are there. And if you want to make a consultation, if for H1B particularly, I would strongly recommend to make with V. Thank you again, guys, for coming, and stay tuned, and we'll be there live next week, Tuesday. Thank you, guys.
Thank you.